Bruno, I've got a question for you here. It says, I rented out a house without a rental or without a lease agreement. I merely occupied the property and paid rent. 2 weeks ago, the property owner sent her daughter to give me 3 months notice to vacate. Within 2 weeks, I was out of the property and found another place to live. Now the property owner is demanding rent because I was out before the 3 months. Why do I owe her money when I left just as the owner asked me to do? What are my rights in this regard? Bruno?
There's no definable terms. So that's already a problem, because typically now we don't actually know what the term of the lease is, right? The default position would then be month to month. When you're looking at longer term leases, and I suppose this is the complication now, whether people consider things as short-term leases and what that defined as versus long-term leases. But the typical tenancy that's not Airbnb or holiday related or short-term related would be a month-to-month contract, unless you can somehow prove that it's longer, like a year or whatever the case is. So Rental Housing Act defaults to 1 month notice. Giving 3 months notice for a person to move out, and it's kind of a strange situation to be in, because now the landlord is under some kind of impression that he needs to give 3 months notice. Yeah, so I mean, I suppose you could argue it both ways. The landlord said, look, you know what? I can give you 1 month notice, but don't worry, I'll give you 3 months for you to move out. Now, the tenant just all of a sudden, without giving any indication, moves out 2 weeks earlier. So this could play out in a couple of ways. Arguably, you could say that if the tenant didn't tell the landlord about this, and the landlord thought that he was going to move out after 3 months, effectively, the tenant only really gave his 1 month notice at the date that he moved out. So I would argue that he wouldn't be liable for 3 months of rent, but the landlord could maybe make out a case that he'd be liable for that 1 month where he suddenly just disappeared and moved out the property, because the landlord had no idea that he was going to move out. And that could be deemed to be his notice period, if you want to put it like that. So from the 2 weeks to basically like 1 month after that. So, you know, that 1 month and a half. So that, you know, that could be one way of looking at it. However, if at the beginning of the 2 weeks, the tenant was clear and going, oh, you're giving me notice, you know what, I'm just going to move out, I'll be out in 2 weeks' time, then no, I don't feel that the landlord would have any entitlement except for possibly, you know, that month, that first month, because it would be a month to month. Saying that it's 3 months would go against the Rental Housing Act, in that the occupier or tenant would actually be allowed to give a 1 month notice period and wouldn't be compelled to sit there for 3 months. Yeah, unless the only exception to this is if the landlord can prove that at some point or another that 3 month period was a term somewhere that was agreed to.
Thanks, Bruno.
If I can throw something in there, Bruno, what's your position? I agree with you 100%. But the Rental Housing Act being pretty clear on your periodic leases having to be a month notice, don't you think that would play harder in favor of the tenant? I think the landlord would have a bit of an uphill battle here to try and convince anybody that they had to stay another 3 months, or what do you think about the Act's application there?
No, absolutely agree with that. So, and that's why I said, unless the landlord can actually prove that there was some kind of express term somewhere that it was a 3 month notice period, I can't see any way that it's not a month to month contract. Like, there's absolutely no way. Yeah.
Okay, happy. We agree.
Yeah,
Yay, we almost had an argument.
So interestingly enough, I've got another question, which is now the opposite of what we just discussed. The previous question, where a tenant leaves too soon, or presumably too soon. This question now for Cilna is where a tenant decides to stay a bit too long past their welcome. And the question is, look, Well, that's exactly what it is. So the lease, the landlord has provided the tenant with notice to vacate. The tenant says, okay, fine, I understand, I have to leave. Finds another place or another, some other accommodation, right? Maybe a lease agreement or a place to stay, whatever it may be. That place is only going to be available in, let's say, 2 months' time. And you got to be out in a month's time, which leaves you with a month of nowhere to go. So the person who asked this question says, if worst case scenario comes and I just decide I'm going to stay on this property for that additional month, what are the repercussions and what kind of legal recourse does the landlord in this instance have against the tenant who stays or overstays his or her welcome? Cilna.
Yay, I'm happy. An eviction question. So the truth is, when a lease agreement comes to an end, and this is actually full circling back to my right of occupation conversation, that personal right of occupation. When that comes to an end, either at the end of the lease agreement because it was a fixed term agreement, that's the end. The landlord gave the notice in terms of section 14 of the CPA, 40 to 80 business days. Everybody did what they had to do. The lease agreement comes to an end. Or it's a month-to-month agreement and a month's notice was given, comes to the end of that. If the tenant does not give the right of occupation back, the only option the landlord has is to commence eviction proceedings. Now, as an illegal occupant, because unfortunately that is what the person will be then, as an illegal occupant, yes, it's going to take 2 to 3 months to get that eviction order. True, but you're probably going to be in for legal costs of around 30 to 35,000 rand. Plus, you're going to be listed on TPN as somebody that had to be evicted. So good luck trying to get a new lease at a later stage. It's a really bad order that you have. Obviously, if your agent does record your payment profile behavior and your in and out behavior, or a next landlord contacts this landlord to find out how things went, unfortunately, your prospects of getting a good landlord in the future really crumbles completely. Also, not all landlords, unfortunately, are law-abiding citizens. And I think those are the landlords that scare me more. It's not my and Bruno's clients, and we are politely going to do actual proper evictions. And I'm sorry, I just said that we might evict one of our viewers, but unfortunately we will, but politely and with a friendly smile. But not Bruno. Bruno won't give a friendly smile, but no, he will. But unfortunately, many landlords does not understand the real effect of section 26 of the Constitution, which says that you have to get a court order to evict. Some landlords, unfortunately, follow their own ways of evictions, and the next moment you might have somebody moving in with you to try and get you to move out, or you might have your utilities disconnected, stuff like that. And yes, you can approach a court to reconnect those and to be placed back in position. But do you really want to go through that effort? So my advice for this particular viewer would be, maybe that property that you found, is they not the right one for you because he's only available 2 months later? Consider staying in an Airbnb for the 2 months, find another property, but to stay in somebody's property where the agreement came to an end is illegal occupation, and the landlord does have the right to commence eviction proceedings. Even if you say, I am going to move out 2 months later, they can still commence those eviction proceedings. And unfortunately, as a tenant and a future tenant, again, it's not really good for your reputation for future rental purposes.
Agreed. I do. So I do find that 1 month, and especially if the tenant legitimately will only stay for 1 month, I do find that situations like this arise very often, and it's sometimes puts a lot more stress on someone that it needs to put on someone. If the tenant doesn't move out for that 1 month, trying to get an eviction and writing letters and spending money isn't really all that much worth it. I would have the conversation with the tenant to see if I can persuade him to move out, or kind of be accepting of the fact that he's going to take an extra month to move out. Make him aware that you're entitled to list him, but also make sure that he pays his rent. So there are, maybe I would suggest over here, and going back to Cilna's Ubuntu principles of, it's honestly, if the tenant genuinely is going, I don't have a place to go, he should move out into a hotel. But if you can afford having that one extra month, maybe just give it to the guy, spare yourself the hassle, get the month rent. Even have an agreement to say, well, he'll cover you for a certain level of your inconvenience, and maybe you get a bit more money out of him in order to cover that inconvenience. Having this conversation might be better than approaching the tenant head on and being confrontational, because you're not going to get anything. Yeah, you'll list him and that's it. You're not going to get him out in that month. It's doubtful, unless he's so scared of the listing. But if he's not, and the new place has already vetted him and he's got the new place, then it becomes a battle of spite, because then it's you phoning the new place and telling them, oh, but he's a bad tenant, and then he's not going to move out the property, and it's just not going to work. So yeah, just do the right thing, I suppose. Yeah, the logical thing.